St. Louis is passionate about the law and helping seniors. This led her to create the Elder Law Group, PLLC, an estate planning and elder law firm that provides asset protection, estate planning, and Medicaid asset prevention strategies. Lynn graduated from the University of Washington School of Law and is licensed to practice in Washington and Idaho. She is a member of the National Academy of Elder Law Attorneys and served as past president of the Washington Academy of Elder Law Attorneys, receiving the distinction of Member of the Year in 2008. Lynn has also received Spokane Coeur d'Alene Magazine's top lawyer rating since 2008, making her one of the region's top trusted attorneys. We are thrilled to have Lynn here with us today, so please help me welcome Lynn St. Louis.
Claire, thank you so much. I really appreciate your kind introduction. Well, welcome everybody. Can you hear me okay? All right. I'm not used to using microphones, and we're so happy to be here at the Active Living Expo, an in-person event where we're going to learn a lot of good information. So during the discussion today, I welcome questions. You can raise your hand. You don't have to wait until I'm done speaking. We'll have time for questions and answers when I am done, but you know, sometimes if something, a question pops up and it's more of a general question, not really a specific question about your particular situation, feel free to ask it as we go along. So what we're going to be talking about today are 5 reasons to put in place a worry-free estate plan. All right? So one of the things that I want to first start out with is not making assumptions, because what happens is I've been in practice for 37 years, and so I kind of assume that people know everything about estate planning and elder law, and I'm wrong in that assumption. So first of all, we are going to talk about you know, what these terms mean. And when I'm saying, what are the 5 reasons to put into place a worry-free estate plan, you might be saying, well, what the heck is an estate plan? And then most people will say, and I sure don't understand what elder law is either. So don't feel like you should understand or have any knowledge of any of these terms. So we're going to start really with some basics on that. So when we're talking about why should you have an estate plan in place, you shouldn't have an estate plan in place because everybody says you should have an estate plan. You should have an estate plan in place because it actually is something that provides protections to you. And as we go through the talk today, these are some of the reasons why you might want an estate plan. Long-term care costs are the #1 threat to a senior's financial security. Was anybody in the room when Heidi just spoke? Okay. I don't know, did she tell you any costs about assisted living, adult family home, skilled nursing? It's expensive. You know, skilled nursing can be over $10,000 a month. It doesn't take long for people to run through their savings at that level. So one of the things that an estate plan can do is help protect you against long-term care costs, and we'll talk about that. Taxes. Most people think, oh, I need an estate plan so that I can avoid taxes. We'll be talking about how, in a situation where you might be facing, your estate might be facing taxes, and the type of estate planning documents that can protect you against paying taxes. I'm really big on this, keeping other people out of your business. An estate plan is the way that you can make sure your voice is heard, your plan is in place, and that you are not having to go to the court or having the state tell you a lot about, you know, what your life should look like. And I know a lot of us want to make sure that we have independence and autonomy, and the estate plan is going to help you with that. Simplifying estate administration, what that means is when you die, we don't want to leave a mess, we want things to be easy. And then, of course, to provide for those you love. So these are reasons and outcomes of an estate plan, but I haven't told you anything about an estate plan yet, so let's get into that. Who in this room thinks you need an estate plan? Everybody needs an estate plan. Good, I'm done, all right. All right, what is an estate? Now, this is something that people get confused about. They think an estate is that nice mansion with acreage and wealthy people have an estate. Well, guess what? An estate is your assets. An estate is a small house on a city lot. An estate is your bank account. An estate is a car. What I mean by that is to have an estate, that doesn't mean that you have to be a wealthy person. Everyone in this room has an estate, be it big or small, it's an estate. So then why would you need an estate plan? Well, again, it's to make sure you are in charge. So what I mean by this is, remember one of the reasons to have an estate plan is so that the state is not involved in your business, because if you have not created your own estate plan, somebody has created one for you, and that is the state. Everybody here has an estate plan, whether you know it or not. Maybe you've gone through the effort and you've met with a lawyer. Maybe you've gone online just to put something in place. If you haven't done any of that, what happens is that if something happens to you, well, we all know death is going to happen at some point. The state has a plan for you, and if you become disabled, the state has a plan for you. So when I say that everybody has an estate plan, what that means is that if you haven't created your own, the state does have a plan for you, and we're going to go through what that means. I kind of want to back up a minute to talk about what is estate planning and what is elder law. So think of it this way. You're born, you go through life, and then you die. A to Z. We all know that that happens. Estate planning lawyers will focus on what happens when you die. And so for a lot of us, what we know is, okay, well, I need to have a will because I need to have some instrument that says where my stuff goes when I die and who gets it. So an estate, and I don't want to make any assumptions. Does everybody know what a will is? Okay, the legal document that says who you are, who your family is, who's going to inherit from you, and what they're going to inherit, and that document has no effect until you die. So when we think of often estate planning, what we're thinking of, what happens when I die? How elder law is different is, yes, we do the estate planning and there will be a will or some sort of dispositive instrument like a trust that says what happens when you die. But what elder law does is it protects you in that in-between time. So you're an adult. And adults, as we all know, don't necessarily live active lives and then die. I would suppose most of us in the room would say, I hope I'm active till the day I die, and I die in my sleep, and I was in control of my life the whole time, and I didn't need to rely on people. I never needed to go to a care facility. I never had dementia. I never lost capacity. We all hope that that's the case. And congratulations for being here at the Active Living Expo, because that's going to help you achieve that result. I hate to talk about statistics, but statistically, over 70% of people will need long-term care. Short period, long period. In my family, mom and dad needed 14 years of long-term care. Dad had his first stroke in 2002, and from 2006 to 2010, he was in the living room of our house. We live with mom and dad, my husband and I, who provided care along with paid caregivers. And he died there in 2010. Then mom needed care from 2010 until 2016. The last 4 years of her life were an adult family home, which, if you heard Heidi talking before this, adult family homes are a great option. So why am I sharing this with you? For one reason, it's why I do what I do. A lot of times what we do in our lives is, affected by what is our family? What does our family need? So in my situation, people just didn't have an active life and died. They had an active life, Dad stayed till he was 72, and then had a stroke, and then for 14 years, we had long-term care in our life. Estate planning doesn't help you with that. Elder law helps you with that. Elder law, that focus is on what documents do you need to protect your voice, so that if you lose capacity, somebody is appointed to speak for you. Your money, if you need long-term care, do you have legal documents that will allow someone like ELG Estate Planning to do Medicaid planning, to use Medicaid benefits for long-term care? That is the distinction between estate planning and elder law. By the way, I'm sure nobody in this room is old enough technically to think that they need elder law, right? I don't know how many times I have heard people say, well, I'm not old. Elder law is for old folks. And no, it's not. Elder law is to give you those extra protections from when you are active until the day you die for whatever life may bring. So part of what we do is we think, what if this happens? What if that happens? What if this happens? We want to make sure that you have the documents and the resources to protect you. You have the right things in place for whatever life may bring, and then we hope that you'll never need any of it. But it is all about protections and plannings. So that is the distinction between estate planning and elder law. So I want to kind of take a moment to say, does that make sense what I said? Do we have questions right now before I move on? Okay. And I don't always make sense. So when I don't, just raise your hand and say, that doesn't make any sense. What are you talking about? All right. So we're going to go over what is the state's plan for you in the various situations that we're going to talk about. So I like to break down estate planning documents so that things aren't so complicated. Really, there's two basic types: living documents and dispositive documents. Dispositive meaning, how are things disposed of? That is when you die. So basically, think of it as two categories. And remember, we were talking about estate planning. Estate planning attorneys will talk about what happens when you die. Those are dispositive documents like a will. But in my opinion, more important than your will are the documents that are your living documents, those that protect you while you are alive. So the most important of those is what we call the general durable power of attorney, because this is the document that you execute while you're alive, and you grant authority to someone to manage your affairs, to be your voice. So the reason we don't want this document ever to have to be used is if somebody is using this document on your behalf, that probably means you've lost capacity. You can't manage your affairs. Has anybody ever served as the attorney-in-fact under a power of attorney? Okay, so, everybody's situation is different, of course, but it can be an easy job or it can be a really tough job, depending on, what happened to the principal, the person who signed the document. So, under a general durable power of attorney, and why I call it general is it means that it is not just limited to one specific transaction. It is in place for whatever the person needs to do on your behalf. And it's called durable, and this is critically important that your document be durable, because durable means it stays in effect even once you have lost capacity. Well, that's the whole purpose of this document. You lose capacity, you've appointed a trusted person to step in and manage your affairs for you because you can't. So when I'm talking about managing your affairs, just think about what do you normally need to do in your life? You need to you know, your income comes in, it goes out from your bank account, pays bills. You know, let's say you need to sell property, for example. You need to have a durable power of attorney. Who in this room is married? Okay. Have you ever tried to call on your spouse's credit card? And you ever got shut down? It's like, I'm sorry, I can't talk to you. I need to talk to your husband. They don't care that I'm his durable power of attorney. So of course he just says, yeah, please talk to my wife. But what if he couldn't say that? What if he was incapacitated? Then, with the durable power of attorney, I would have to provide it to the credit card company, and then they'll speak to me. You might own a house with your spouse, and maybe you need to sell it, but your spouse has lost capacity. What do? You cannot sell your house unless you have a durable power of attorney. Both of your names are on the title. Both people need to sign it to sell it. And even though you're married, even though we're a community property state, you can't sell that house unless your spouse signs the paperwork or you have a durable power of attorney that says you can sign on their behalf. And this really surprises a lot of people. And it surprises people at a time when they don't want a surprise, because if you're dealing with a spouse who's incapacitated, you're dealing with some struggles. It's very difficult. I guess I shouldn't have made an assumption. Has anybody ever had to help somebody with long-term care, somebody who's incapacitated, Alzheimer's, care providing? It's a very rewarding job and a really difficult job. And so the last thing you want is to run into legal difficulties when you're trying to help somebody else. You need a durable power of attorney. If you don't have one, you're not going to be able to do the things that you want to do. This next thing here says make gifts. Why would you ever want to make gifts? As a Medicaid expert, I'm going to tell you, don't gift unless you have in writing from an elder law attorney who says that they have expertise in Medicaid, that you should gift. Because gifting, Medicaid has a 5-year look back. If you make any gifts within 5 years, Medicaid's going to say, what'd you give your money away for? That person needed money to pay for their care. So don't do gifts unless it is a part of a plan that the lawyer has put in writing that this is a smart plan and this is the plan we're going to implement for Medicaid asset preservation strategies. We don't have time today to go through all the Medicaid asset preservation strategies. All I want you to know is that there are strategies that do exist. Medicaid is an impoverishment program for single people. You can only have $2,000. You can have your house, your car. For a couple, you can have more money than that, basically between $60,000 and $135,000. But I want you to know, and I'll go through an example a little bit later, that there is the ability to qualify for Medicaid benefits with far more assets than what I just stated. How do you do that? You know what Medicaid's rules are. You work with a Medicaid planning attorney. But as a Medicaid planning attorney, I can't do any of these Medicaid strategies if I have an inadequate durable power of attorney. So one of the things that an elder law attorney will do that an estate planning lawyer won't do is we will put provisions in our durable powers of attorney that allow the type of transactions that need to be done to qualify for Medicaid. So when you go to an estate planning lawyer, of course I recommend that you go to a lawyer, not do online. But, yes?
Does gifting include tithing to the church?
No, that's a great question. Gifting does not include tithing. Tithing is a regular event, and so when Medicaid looks at it, they see that. Now, if you're trying to make up for tithing you haven't done for the last 5 years, that's a problem. So, yes?
Regarding the selling property, so if one spouse is incapacitated and the other is not, can that spouse still sell a car, sell a house, or do you need to be away?
So, unless, the question is if one spouse is incapacitated, the other is not, can the spouse who has capacity, can they sell property? The answer is no, you cannot. Because the spouse whose name is on the deed or the document has to sign. So you need a durable power of attorney in order to sell the asset, even though you're married. So this really takes people by surprise. And if you don't have that, then you're gonna be under the court's plan. Remember, you either have your own plan that you put into place, or you have the state's plan. If you have your own plan, you're gonna have a general durable power of attorney to protect you from whatever life's gonna bring. If you haven't taken that step, that action to protect yourself with your own plan, the state's plan is what's in place for you. And if you are married, your spouse is incapacitated, you need to sell your property, and you don't have a durable power of attorney over your spouse, the state will become the decision maker, even though you're married. There will be a guardianship, a court-ordered conservatorship, a guardian, or as of this year, we're now calling it conservator in our state for finances. And everything you do has to be run through the court, everything. So here you are, owner of this property, and you can't sell it because the court has to give you legal authority to sell it. Believe me, that's an extraordinarily frustrating place to be in. It makes no sense for the most part, but that's what our laws are. And this is one of the reasons that I love to do these educational presentations, because I want everybody in the room to know, if you don't have a durable power of attorney with your spouse, and one of you loses capacity, you will be in a court-ordered guardianship, and all of your freedom is gone. Yes?
So does that require two different documents, or can they cover the couple in a durable?
Yeah.
attorney?
Each person should have their own individual document. Because you have to sign. I grant authority to my spouse to make decisions for me. He has a document where he says the same thing. And we just talked about why you might want to have a gifting authority and a power of attorney. It's so that we can apply for Medicaid government benefits. So with the authority that is granted comes a whole lot of responsibility. The attorney, in fact, that trusted individual that you've appointed under your durable power of attorney, has responsibilities. They are called a fiduciary, and they have to keep track of everything they do. They can't use money for themselves. They need to use it for the benefit of the principal, the incapacitated person. And when we do durable powers of attorney at our office, we recommend that they take effect immediately, even though you are fully capable. Because if you make it springy, meaning it doesn't come into effect until you lose capacity, then you have to get a doctor or two to sign off on the fact that you've lost capacity. And if you've ever dealt with anybody with declining capacity, it waxes and wanes, and it's difficult to get a doctor to say, oh yeah, mom doesn't have capacity or this or that. So we recommend that they be effective immediately, and you're appointing somebody you trust. You give them the document, you say, I want you to know you're my attorney in fact under my power of attorney, and I'm perfectly capable, so of course you don't need to do anything until you see I need help. And if that's not comfortable for you, then maybe you're not appointing the right person. If you think they're gonna step in and start acting prematurely, perhaps there should be another person that you can trust that won't act until they need to help you. And the person, the attorney in fact, they're also called the POA, basically they should be simply acting on behalf of the person who needs help. All right, so I just covered financial powers of attorney. It really is the most important legal document you can have. And as an elder law attorney with Medicaid focus, I often run into problems with the documents that I see from estate planning lawyers. They won't give the authority to do a transfer on death deed or a gift for Medicaid or a separate property agreement for spouses, or there's numerous authority that has to be specifically laid out in a financial power of attorney. And if it's not there, my hands are tied. And if my hands are tied, then I can't help preserve assets to the extent that I could otherwise. So another document, this is again another living document, it's called a healthcare power of attorney. It's same conceptually as the financial one, but it speaks to your healthcare matters, your medical decisions, those sorts of things. So if you lose capacity, remember all I'm talking about right now are people losing capacity. What we don't want ever to happen, but this is what elder law really focuses on, is what if you lose capacity? If you can't speak for yourself, you really want somebody else to speak for you. Talk to your doctors. You know, who should you appoint? Same with both of these, financial and medical. Somebody you trust, somebody who's a capable and effective advocate for you. They don't have to have medical training, but they need to be sharp enough to ask questions, to follow whatever the doctors are telling them, and to make decisions, and sometimes those are hard decisions. Now, one of the things that I very much recommend is whomever you're appointing, let them know that you've done so. It really comes as a surprise, right? When, what? I didn't know I was your healthcare agent. You say to the person who's lying in the hospital bed, you didn't tell me this. That's an unpleasant surprise. And also you're telling them, you want to be talking to them, giving them information that they might not know so that they can be your best advocate for you. Now, it is not necessary that your powers of attorney be separate documents, one for finances and one for healthcare. We, at our office, typically draft them separately because maybe your financial power of attorney is your son, your healthcare power of attorney is your daughter. There's all sorts of reasons why you would want it to be a separate document. So, and especially our documents are pretty robust. They really cover all bases. But you'll see, especially online form documents will be combined into one, and there'll just be one paragraph that says, this person is my healthcare agent. There's nothing wrong with that legally, but from an elder law perspective, when I am trying to help protect you, your family, and your money, I'd like to have a more robust document that allows us to do whatever planning would benefit you. Yeah. Oh, over here. Yes, sir.
Would you recommend somebody that you appointed, POA, to talk with the elder law like you?
Yeah, that's a great question. So the person you've appointed under your powers of attorney, they're called your agent, your attorney, in fact, your POA. The question is, should they come talk to the attorney that drafted the document? The answer is yes. We like to encourage, once our client has signed the document, who have you appointed? It could be a spouse, it's usually a son or daughter or somebody. Come in and let's go over all the documents. Let's give them an understanding of what they should be doing. So yeah, I think it's a great idea for that person to come in and speak with you, me, at a group meeting.
When you can't do that, like my granddaughter is our attorney, and she's in Billings, Montana.
Mm-hmm.
Is there people that would go talk to her then from Billings?
We Zoom, phone call, video, I know. We just came out of the world of 2 years of Zoom. Nobody probably wants to do it anymore, but there are ways to communicate with people who are remote. Of course, we all know the phone call. That's one way to do it. If it's your granddaughter, she probably would be happy to Zoom video on the computer, yeah. Yes, sir, in the back.
In durable power of attorney, do you have then backup in case people are?
Great question. You want backups on your power of attorney. Remember I said what we do in estate planning and elder laws, we say, what if this, what if that? Well, what if you, nominate your spouse and you and your spouse are in the same car accident? Who's backup? Well, then it's gonna be my daughter. Okay, what if all three of us were on a plane somewhere, and now who's backup? My son. So we like 3 levels of backup, actually. Yeah, it's a really good question. And I do not like joint decision makers. I don't want it to be a committee. Appoint somebody who will make the decision. but do appoint backup successors. The reason that you want that is if you run out of successors and you don't have a mechanism in your document to appoint somebody else, the document fails and you're in court under a court of guardianship. We put in our powers of attorney that none of these people can serve, then the majority of the adult members of my family can appoint somebody, because we always want to keep the decision-making authority within those people who are my family, not the court. You guys have great questions, keep them coming, thank you. Yes, sir?
In the absence of a trusted person, do attorneys serve as attorneys in fact?
In the absence of a trusted person, do attorneys serve as attorneys in fact? I can't speak for all attorneys. I know at our firm we don't do that. That's not the best use of our time and your money. Lawyers cost money. So the better use is to hire, there are professional fiduciaries. For example, let's say you have money under investment at Washington Trust Bank, they'll be your financial power of attorney. Or Northwest Trustee and Management, they have a fiduciary service. They'll serve as a professional attorney in fact for you. And you know, it's more common that people appoint family members, but it's not uncommon that a professional needs to be appointed. And when it comes to healthcare, you can ask around with the booths here, but I do know various healthcare agencies will serve as your healthcare agent. Village Plan is one of them. Of course, they charge money, and so that's kind of the resistance to appointing a professional, but sometimes it is the best option. So this is the third living document, and it is called, commonly it's called a living will. It is an advance directive, it is a healthcare directive. What this document is, it says, if I'm at end of life and the doctors have put in writing that no, they can't, you know, make me any better, then I don't want heroic measures, you know. Stop the heroic measures is what a healthcare directive typically says. It's your end of life document. By putting your wishes in writing, I'm a big fan of putting things in writing. It's not just for memory, it's for clarity. But if you put things in writing, then people can read what you said and there's going to be less confusion about it. So you're not going to have a fight. Remember Terry Shivo out of Florida, anybody? Right, she was in her 20s, of course she didn't have it in writing. So rare is the 20-year-old that has an estate plan. Do any of your 20-year-old family members, are any of you lawyers? My 20-year-olds did, because mom insisted. But, so, you know, in the Terry Shivo case, of course, the husband and the family, her parents were in disagreement over what her treatment should be, and it was terribly sad and very burdensome on everybody involved. If you put your wishes in writing, you know, if your wishes are, you know, withdraw heroic measures, then you've clearly stated it, and you're gonna alleviate that guilt that somebody has when they say pull the plug. Some people say, but I want to make sure that if I need help, I'll get help. You will get medical help. The healthcare directive, living will, does not come into play until the doctors have given you all the treatment that they can think of that's going to make you better, and then they put in writing, it's not working. So until then, you are getting all the emergency treatment, etc., that the medical field will be able to provide to you. So don't worry that you sign a healthcare directive and that means, you know, you're not going to go see the doctor, you're not going to get emergency help. You will. The only document that can keep emergency responders and doctors from providing you certain help is the PLLC form. Do you know which form I'm talking about? Has anybody seen it? That lime green form? Usually it's put on your refrigerator. It's a physician's order on life-sustaining treatment. That is the document that if you do not want the emergency responders to try to resuscitate you when you stop breathing, they have to see that document. If they don't see that document, you're going to get CPR. That's what the law requires. Now the PLLC form is not a form that you get from your lawyer's office, you get it from your doctor's office. And before you sign one, you want to have a conversation with your doctor, because a pulse form generally is inappropriate unless there's a good reason for you to have it. And I can't speak to that, speak to your doctor about that. Okay, the majority of my talk is on living documents because we've just covered the three: financial power of attorney, healthcare power of attorney, healthcare directive. Those are the documents that protect you while you are alive if anything happens to you during your adulthood. Those are, in my opinion, the most important documents you can have, and I would say that an elder law attorney is going to better serve you in making sure that those documents are robust, because as an elder law attorney, what we deal with is aging, incapacity, long-term care, Medicaid, how do you pay for care? So all of those things are always on my mind when I'm saying, how are we gonna help this client? So you'll have more robust documents with, if you're being served by an elder law attorney. Oh, and one of the things that I also wanna say is that, you know, lots of lawyers will provide wills, and we're gonna talk about the different kinds of wills and what protections are in them. But when you're going to somebody who's drafting your estate plan, ask them questions like, you know, if I get Alzheimer's, or if my spouse does, or a stroke, or something happens, how are you gonna help me? How are these documents gonna help me? How is this plan helping me? They should be able to articulate plainly and clearly to you how they're gonna be there to help you. You can even go to the question, and what if I need expensive long-term care? How are you gonna help me so that I don't go broke paying for my care or my spouse's care? They should have a good answer for you, which is, you know, through these documents, that we would be able to do a Medicaid strategy. A lot of lawyers don't touch Medicaid because it is a very specialized area of law. So just like everybody, you know, you don't want to be a generalist, you want to be a specialist, right? Any of these doctors that are talking, the orthopedist, you know, you're going to go to the orthopedist for your rotator cuff surgery, not to your family practitioner. So ask the questions, will you be here? Will the law firm be here for me throughout the end of my life? Or will my family be able to come to you? And will you be able to help us with whatever situation arises? And frankly, our law firm doesn't help everybody with everything arises. If it's an elder abuse case, or a litigation matter, or a family dispute, we're not gonna be able to say, oh, we can handle that in-house, but we will help guide you to the right person. But if you need long-term care, or somebody in your family does, and you wanna know, how do I get Medicaid benefits, we're there for you. That's all part of what we've already thought about when we did your estate plan. So that's a distinction that elder law has from estate planning. All right, will. Now we're moving to the documents. The second category of documents are what happens when I die. A will has no effect until I die. A will says where your assets go when you die. Now, most people want to say, well, when I die, I want my spouse to get everything and I want it to be really simple. Okay. But I want you to be aware that a will can protect assets for those who inherit from you. So here's a situation. What if my spouse had Alzheimer's? I don't want him to inherit from me outright. He can't manage the money, and plus, if he's got Alzheimer's, he's likely going to go into memory care. And so I want to protect those assets for him, for his benefit. So oftentimes people say, I just want a simple will. I know what they're saying, I just want to simplify my life, and it's already too complicated, and don't make it any more complicated for me. But it's my obligation to say, all right, but let's talk about your situation. If your spouse has Alzheimer's, we don't want him to inherit outright. We want to protect those assets for him. A will can do that. And how we do that, and protecting assets and protecting your beneficiaries is along the same lines. We want to protect the money for my spouse. How do we do that? we're going to include in the will an asset protection supplemental needs trust. Big long word for say the type of trust that the state honors for protecting assets for your spouse. So, let me see, I'm not quite sure what my next thing is. All right, so it helps you qualify for Medicaid. It doesn't have to be Medicaid though. Let me give you an example. Let's say you and your spouse own a house, and I'm gonna be really simple in my math. You've got a house that's worth $500,000, and you've got $500,000 in investments, IRAs, bank accounts. So you and your spouse have $1 million. Sounds like a lot of money, right? Not if you have long-term care costs, and that's gonna go away at $150,000 a year. That money is gonna go away. So, under the situation where the couple has $1 million, half of it's in a house, half of it is in liquid assets, one of the spouses has Alzheimer's. Oh, and by the way, get the estate planning documents in place before that cognitive decline has progressed so far that you can't sign documents. All that we're talking about getting estate planning in place is you've got to do it while you still have the cognition to do so. Once that's gone, you're under the state's plan, not your own plan. So, back to my example. The husband has Alzheimer's. Let's have the wife die first. She's the one that's really concerned because she knows her husband can't take care of herself. Alzheimer's or not, no, I'm kidding, joking. So the wife dies. What is going to happen next? Well, usually once she dies, and she's been taking care of her husband at home, he's not going to be able to stay there any longer. It's very hard for an Alzheimer's patient to live on their own in a house. So she dies. The $500,000, her half of the estate, is going to go into a trust created by her will for her husband's benefit. All the money in that trust is not considered his money. If it was outright without a trust, it would be. But we're putting it into this trust, this asset protection trust that her will creates for him. And that means that Medicaid isn't going to count that money as his. It's not, he doesn't own it. A trustee is somebody who is not him, is in charge, but it is for his benefit. He doesn't own it. This money in this trust doesn't count against him for Medicaid. Remember, Medicaid has strict financial standards. It's not going to count as his. So, $500,000 goes into this trust. The house is $500,000. The state allows you to have a house and go on Medicaid. So this gentleman can go on Medicaid after his wife dies, pay for his care, and he didn't have to spend down any money. What he has is a house that's worth $500,000, a trust that benefits him that has $500,000 on it, and he's eligible for Medicaid. So, this usually is an eye-opener. People say, I can protect money, my spouse doesn't have to spend down everything. That's right. But maybe you're saying, I don't want my spouse to go on Medicaid. He needs to go to this memory care facility. It's got a 2-year private pay. Great. Don't jeopardize his quality of care. Use that money. Well, actually, if he's going to move to a care facility, he's probably going to sell the house. So sell the house, use the proceeds, privately pay at the care facility for however long, and then he can go on Medicaid at the same care facility and still have $500,000 in trust. So, questions, because usually people say, that doesn't make any sense to me. I thought Medicaid had a 5-year look back. Not when it comes to wills. No look back with wills. How do you protect your spouse? You have a will with an asset protection trust in it. Doesn't have to be just for your spouse. This could be for anybody. You might have a child who is on government benefits or has lifestyle issues. There's all sorts of reasons you might not want your beneficiary to inherit outright. You might want to protect the money for them. I think I already covered that. Yes, sir.
So you have $500,000 in a trust for that person's benefit. How does that money benefit that person?
Well, let's say, and let's change my example a little bit. and let's say that, you know, the house wasn't worth so much money or something, all that money in the trust can be used for the beneficiary. It's for their sole benefit. So anything in the trust can be used for and is to be used for that person who needs care. So let's say that they need to dip into that money to pay for 2 years of private pay. Okay, use that money. It's not gonna go through the 500,000. There's still gonna be money left for that person, and they're on Medicaid. Then what do you need that money for? You know, once you're on Medicaid, you get to keep like $70-some per month for haircuts and stuff. Medicaid pays for everything else. Maybe you use that money for somebody to come and sit with them and read to them, or there's all sorts of ways that money can help provide better care. But Medicaid will be paying the majority of the costs. All right, so everybody has heard of a revocable living trust, yes? Nobody understands what it means, yes? Whenever you hear the term trust, just say, and we're talking about a legal document, just say, okay, stop, no, explain a little bit more about this. What is it? Because I've just been telling you about an asset protection trust created by a will. That is called a testamentary trust, and it is a asset protection trust, and it has different terms than a revocable trust. So don't expect to understand when somebody says the term trust that you know what they're talking about. Ask more questions. And don't feel badly about asking more questions. So, we just talked about a trust that's created by somebody's will. That means that trust wasn't created until somebody died. A will has no effect until there's a death. Now we're moving to talk about a living trust, revocable living trust. These are very commonly promoted estate planning tools to everybody in this room. Why is that? The reason is that a revocable living trust is intended to manage all your assets. You're in charge while you're alive, and when you die, whomever you want to get your assets will get them without the need of a probate. That is the key selling point for revocable living trusts. And candidly, they make a lot of sense in some situations, and in others, they do not. So before somebody says, or you say, oh, I want a revocable living trust, you have to ask more questions. So let me break it down a little bit more. Who is the trustor? What is a revocable living trust? Let's start with that. It's a legal document you sign. And it can be a couple of pages or it can be 80 pages. You've probably seen the gamut of those. So if you have a revocable living trust, you are the trustor or the grantor. You've created this, probably with the help of a lawyer. You are the trustee, which means you're managing everything in the trust. And you are the beneficiary, meaning everything in the trust is for your benefit. This is why it gets so confusing. It's like, what are all these legal terms? I mean, why don't I just leave my money in a bank account where, you know, I'm in charge of it there? Well, again, the whole purpose of the primary purpose of a revocable living trust is so that you avoid a probate when you die. That is the primary purpose of a revocable living trust. So, who thinks probate is the best thing you could possibly do for your estate? All right. I never get a hand raised on that, by the way. So, in the state of Washington, if you want to protect assets for your spouse when you're gone against long-term care costs, you have to do it through your will. And if you have a will, and through that will, you put $500,000 into that asset protection trust for your spouse, there's one way that that happens, and that's through a probate. A probate is the legal process, and I don't remember if I have a slide on it, I don't think I do, where the will is filed with the court, the person who is, I think I might have a slide on this, I'm gonna need to wrap up here. Yeah, okay. Probate is a legal process to administer your estate when you're gone. And the will is filed with the court, personal representative or executor is appointed, and they're granted legal authority, whoops, went too far, through letters testamentary. And if you've heard of probates, or if you've been involved in probates, your experience might have been good, might have been bad, might have been confusing. Probate is not something that is a commonly understood thing, because you don't do it. It's done when somebody dies. And if you're going through a probate as the executor, you're going through a difficult time, your loved one has died, you have all this work to do. This is why people want to avoid probate. By the way, all of those things happen when somebody dies anyway. You have to go through all their stuff and manage everything, whether it's a trust or not. Probate, though, means the will is filed with the court, and you are granted authority as the executor to take whatever actions you have to. Probate in Washington and in Idaho is a very simple but statutorily laid out, do this, do this, do this, do this, do this. So why would you want to probate? Well, do you want to protect money for your spouse when you're gone against long-term care costs? Only way you can do it in the state of Washington is if you have a will that creates a trust. That means the trust had to be implemented, brought into life through a probate. Go ahead.
Is that also true in Idaho?
In Idaho, that is questionable whether it's true. The standard of practice for elder law attorneys in Idaho is to do the same as in Washington, which is a testamentary supplemental needs trust. So some states allow protection of assets without a probate. California does, for example, because in California, probates are based on the cost of a probate is based on the percent of the estate. Who wants to pay 10% of $1 million to probate? So California doesn't require it. Typically in Washington state, how probates do cost money. You do go to a lawyer. You could do it on your own. We actually even have do-it-yourself probate, but we typically find that people need legal help to get through a probate. Anytime you're talking to a lawyer about your estate plan, or about help with Medicaid, or about a probate, or any kind of service that we provide, we charge you money. And people, understandably, would say, you know, I don't want to pay more than I have to pay. So my goal is to help you explain why you might want to pay $5,000, $7,000, $500, even $10,000 for a probate if the outcome of it is that you've protected $500,000 for your spouse. That makes sense to do it. It's the only way you can do it in our state is through a probate. And if you have a good estate plan in place, it's going to be far simpler than if you have the state's plan in place, which won't protect any money, will cost you money, and get no good benefits from it. So probate sometimes is a really, really smart way to go. And if it's not, then your estate planning and elder law attorney should set up your estate to avoid probate. Oftentimes we completely avoid probate. The couple doesn't want to have any kind of asset protection, or there's no reason, they don't have a big enough estate that they want to set up a certain trust to minimize taxes. If that's the situation, we use what's called a community property agreement. And then when the first spouse dies, everything automatically is vested in the surviving spouse. There's no need for a probate. We didn't do one. But you see, whatever we do it mindfully, so that whatever benefit to you is going to accrue to you, is going to come to you. That's a good estate plan. That's the right estate plan for you is one that looks at your situation and accomplishes your goals so that you get the best outcome. That's what I'm encouraging everyone to get and to understand is what is the right estate plan for you, because it's not going to be the same thing for every person. Everybody has a different situation, and you frankly need to understand what is your situation and how can an estate plan benefit you? How can the right estate plan benefit you? And you know, once you have that understanding, then getting an estate plan, I'll say it this way. Who likes to go to the dentist? People like to go to elder law estate planning lawyers even less. I understand that, but we really can provide a lot of help and guidance and protections. And wherever whoever your attorney is, hopefully I've provided you some information, you can start asking questions of them. Of course, you know, we would welcome you to come see us as well. We're ELG Estate Planning. I want to thank you for being here. I know we're just coming up to the end of our time here.